Hi, my name is Corey Biazzo, and I'm a practicing American civil litigation attorney, and you are watching Executive Coup. In today's episode, we're going to discuss the legal issues surrounding the Trump administration's use of the federalized California National Guard and active duty U.S. Marines to respond to protests in Los Angeles, California this month. On June 12, 2025, Judge Charles Breyer of the U.S. District Court of the Northern District of California found that the Trump administration's domestic troop deployment violated the 10th Amendment of the U.S. Constitution, in addition to violating a federal statute, specifically 10 United States Code, Section 12406. As a result, the court entered a temporary restraining order stating, quote, "Defendants are temporarily enjoined from deploying members of the California National Guard in Los Angeles. Defendants are directed to return control of the California National Guard to Governor Newsom." However, later on June 12, 2025, the U.S. Court of Appeals for the Ninth Circuit issued a temporary stay of Judge Breyer's order while the Trump administration litigates its appeal of the trial court order. On June 19, 2025, the appellate court extended its stay of the trial court order based on its review of 10 United States Code, Section 12406, stating, quote, "We are persuaded that under longstanding precedent interpreting the statutory predecessor to Section 12406, our review of that decision must be highly deferential. Affording the President that deference, we conclude that it is likely that the President unlawfully exercised his statutory authority under Section 12406, subsection 3, which authorizes federalization of the National Guard when the President is unable with the regular forces to execute the laws of the United States. Additionally, the Secretary of Defense's transmittal of the order to the Adjutant General of the California National Guard, who is authorized under California law to issue all orders in the name of the governor, likely satisfied the statute's procedural requirement that federalization orders be issued through the governor. The appellate court stay of the trial court order remains in place while the substantive issues of the appeal are reviewed, which will likely require further briefing from the litigants. The trial court order provided initial background by stating, quote, "On June 6, 2025, the federal government initiated immigration raids across the city of Los Angeles. Protests swiftly followed, and some individuals involved in those protests were unruly and even violent. State and local law enforcement responded. The following day, President Trump ordered that members of the California National Guard be federalized and thereupon assume control of those forces. At this early stage of the proceedings, the court must determine whether the President followed the congressionally mandated procedure for his actions. He did not. His actions were illegal, both exceeding the scope of his authority and violating the 10th Amendment to the United States Constitution. He must therefore return the control of the California National Guard to the governor of the state of California forthwith." The trial court further stated in its order regarding the LA ICE raids on June 6, 2025, quote, "Los Angeles Police Chief Jim McDonnell stated that federal officials did not brief his department, which made it difficult to respond to the mobs of people who began to protest. ICE reportedly targeted several locations in downtown LA and its surrounding areas, which included 2 Home Depot stores, a donut store, and a clothing wholesaler. Ultimately, between 70 and 80 people were detained and 44 arrested." The trial court further stated in its order, quote, "That evening, protesters reportedly marched in downtown Los Angeles. There were about 800 protesters at 2 sites. Some protesters threw concrete chunks, bottles of liquid, and other objects at Federal Protective Service officers guarding a parking lot gate. Some protesters attempted to use large rolling commercial dumpsters as a battering ram. Some of the protesters used chairs, dumpsters, and other items as weapons. LAPD declared an unlawful assembly, and while some individuals resisted, the protesters departed by 11 p.m. 2 federal buildings were vandalized and sustained minor damage. The trial court judge then outlined the continued protests that occurred on June 7, 2025 in LA, with a small amount of protesters again getting violent. The trial court judge continued, stating, quote, President Trump intervened in response to the protests on the evening of June 7th, issuing a memorandum to the Secretary of Defense, Attorney General, and Secretary of Homeland Security. President Trump directed Secretary Hegseth to coordinate with the governors of the states and the National Guard Bureau in identifying and ordering into federal service the appropriate members and units of the National Guard under this authority, calling for at least 2,000 National Guard personnel to be on duty for 60 days or at the discretion of Secretary Hegseth. Finally, the memo provided that Secretary Hegseth could, quote, employ any other members of the regular armed forces as necessary. Secretary Hegseth issued an order that same night, attaching the June 7th memo and announcing that 2,000 members of the California National Guard were being called into federal service effective immediately for 60 days. The order further stated that the commander of U.S. Northern Command would control the 2,000 National Guard members. Defendants did not notify Governor Newsom of their intent to federalize the California National Guard prior to issuing the June 7th memo or the June 7th DOD order. President Trump wrote on social media that he had directed his cabinet officials to, quote, take any actions necessary to liberate Los Angeles from the migrant invasion, and said, we're going to have troops everywhere. That same day, Governor Newsom's office wrote to Secretary Hegseth stating that the June 7th DOD order did not comply with the law or even with President Trump's June 7th memo. The letter argued that local law enforcement resources are sufficient to maintain order and that deploying the National Guard without adequate training or orders risks seriously escalating the situation. The letter asserted that the deployment represented a serious breach of state sovereignty that seems intentionally designed to inflame the situation. The letter asked Secretary Hegseth to rescind the June 7th DOD order. Instead, on June 9th, Secretary Hegseth posted on social media that, quote, approximately 700 active duty U.S. Marines from Camp Pendleton are being deployed to Los Angeles to restore order and defend federal law enforcement officers. Secretary Hegseth then issued a second order federalizing another 2,000 National Guard members for 60 days. The 10th Amendment of the U.S. Constitution states, quote, the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. One power specifically bestowed on the states through its lack of reservation for the federal government in the U.S. Constitution is the general police power, which gives the state governments the inherent authority to promote the safety, health, welfare, and morals of their citizens. 10 United States Code, Section 12406, titled National Guard and Federal Service, states, quote, whenever 1. The United States or any of the commonwealths or possessions is invaded or is in danger of invasion by a foreign nation. 2. There is a rebellion or danger of a rebellion against the authority of the government of the United States. Or 3. The President is unable with regular forces to execute the laws of the United States. The President may call into federal service members and units of the National Guard of any state in such numbers as he considers necessary to repel the invasion, suppress the rebellion, or execute those laws. Orders for these purposes shall be issued through the governors of the states, or, in the case of the District of Columbia, through the commanding general of the National Guard of the District of Columbia. The trial court, in its order, conducted a review of the 3 subsections of the statute. Subsection 1, regarding foreign invasions, was easily ruled out. In evaluating subsection 2, the court conducted an analysis of whether a rebellion, as contemplated by the statute, had occurred, which could have authorized President Trump's calling of the California National Guard into federal service in LA. The judge stated, quote, Section 12406 does not define the term rebellion, so the court must interpret the term consistent with its ordinary meaning at the time Congress enacted the statute. The judge quoted the late U.S. Supreme Court Justice Antonin Scalia in the order and stated, quote, "And where there are multiple dictionary definitions, the court must apply the contextually appropriate ordinary meaning unless there is reason to think otherwise." The judge further stated, quote, "Both parties quote the definition of rebellion from the current edition of Black's Law Dictionary, which is 1. Open, organized, and armed resistance to an established government or ruler, especially an organized attempt to change the government or leader of a country through violence." The court's own research has turned up the following definitions from the late 1800s and early 1900s, the relevant time period for understanding what Congress meant when they passed the Militia Act of 1903. Deliberate organized resistance by force and arms to the laws and operations of the government committed by a subject. The court covered several other dictionary definitions of the word rebellion from the time around 1903 when the statute was passed. From there, the court observes that the dictionary definitions from the turn of the century share several key characteristics. First, a rebellion must not only be violent, but also be armed. Second, a rebellion must be organized. Third, a rebellion must be open and avowed. Fourth, a rebellion must be against the government as a whole, often with an aim of overthrowing the government rather than in opposition to a single law or issue. The protests in Los Angeles fall far short of rebellion. Most protesters demonstrated peacefully. Nonetheless, it is also beyond debate that some individuals use the protests as an excuse for violence and destruction. Violence is necessary for rebellion, but is not sufficient. Even accepting the questionable premise that people armed with fireworks, rocks, mangoes, concrete, chairs, or bottles of liquid are armed in a 1903 sense, the court is aware of no evidence in the record of actual firearms. There is little evidence of whether the violent protesters' actions were open and avowed, nor is there evidence that any of the violent protesters were attempting to overthrow the government. As a whole, the evidence is overwhelming that protesters gathered to protest a single issue, the immigration raids. The court is troubled by the implication inherent in defendants' argument that protest against the federal government, a core civil liberty protected by the First Amendment, can justify a finding of rebellion. Applying these principles, courts have repeatedly reaffirmed that peaceful protest does not lose its protection merely because some isolated individuals act violently outside the protections of the First Amendment. The trial court then addressed the third subsection of the statute. Quote, "The third condition justifying the federalization of the National Guard and the second advanced by defendants is that the president was unable with the regular forces to execute the laws of the United States. Defendants concede that ICE succeeded in arresting 44 people on June 6, but insist that the limited success came with the risk of danger, and that had the protests not interfered with their operations, ICE would have been able to carry out additional execution of the law's activity. Whether ICE could have detained more people in the absence of the protests is mere conjecture. Defendants provide no support for that assertion. Even assuming that defendants are correct, however, the statute does not allow for federalizing of the National Guard when the president faces obstacles that cause him to underperform in executing the laws. The statute requires that the president be unable to execute the laws of the United States. That did not happen here. A classic example of a president being unable with the regular forces to execute the laws. Indeed, the only time in this country's history that a president has exclusively relied on Section 12406 to federalize the National Guard is the 1970 Postal Service strike. On March 23, 1970, President Nixon declared a state of national emergency, ordering 25,000 personnel from the National Guard and other military branches into New York to get some mail moving. In that case, the mail system was incapacitated. The, quote, regular forces of letter carriers were on strike, and there was no other way to deliver the mail. In this case, the regular forces were and are still very much on duty. While ICE was not able to detain as many people as defendants believe it could have, ICE was nonetheless able to execute the federal immigration laws. Indeed, ICE continues to carry out enforcement actions executing those laws. The trial court then went on to discuss the administration's apparent failure to comply with the procedure to issue orders through the governors. quote, shortly after enacting the Militia Act of 1903, Congress amended the act to require that any orders issued under Section 12406 be issued through the governor of the respective state, from which state such troops may be called. Plaintiffs assert that President Trump failed to comply with this procedural requirement. They explain that Governor Newsom first learned that President Trump had called 2,000 of California's National Guard members into federal service when California's Adjutant General forwarded him the June 7th DoD order. From that point on, the commander of U.S. Northern Command, not the governor, has issued all orders to the federalized National Guard. Defendants assert that they complied with Section 12406 because written at the top of the June 7th and June 9th DoD orders was the label, quote, through the governor of California. True enough, but an interpretation of Section 12406 that permits the president to federalize a state's National Guard by typing the phrase, quote, through the governor of insert state here at the top of the document that the president never sends to the governor strains credibility, especially given that Congress specifically amended the statute to add the requirement that orders shall be issued through the governors. Section 12406 specifically requires that orders federalizing the National Guard be issued through the governor of respective states, not through a different state official, even one who can issue orders in the governor's name. Indeed, when Congress has wanted to accommodate other state officials, it has done so expressly. The trial court then addressed the plaintiff's third argument regarding the Posse Comitatus Act. First enacted in 1878, the act prohibits military personnel from acting as a posse comitatus or those upon whom a sheriff could call for assistance in preventing any type of civil disorder. The current version of the act, 18 United States Code section 1385, provides, quote, whoever except in cases and under circumstances expressly authorized by the Constitution or Act of Congress willfully uses any part of the Army, the Navy, the Marine Corps, the Air Force, or the Space Force as a posse comitatus or otherwise to execute the law shall be fined under this title or imprisoned not more than 2 years or both. The trial court quoted the U.S. Ninth Circuit Court of Appeals in a 2015 case called United States v. Dreyer, stating, quote, the act reflects a traditional and strong resistance of Americans to any military intrusion into civilian affairs that has deep roots in our history and found early expression, for example, in the Third Amendment's explicit prohibition against quartering soldiers in private homes without consent, and in the constitutional provisions for civilian control of the military. The trial court further stated, quote, plaintiffs are correct that President Trump and Secretary Hegset's federalization of the National Guard requires National Guard members to violate the Posse Comitatus Act. The trial court further stated, quote, defendants failed to grapple with the second part of plaintiff's 10th Amendment claim that their use of the National Guard and the Marines comes into conflict with California's police power. It is well established that the police power is one of the quintessential powers reserved to the states by the 10th Amendment. It is not the federal government's place in our constitutional system to take over a state's police power whenever it is dissatisfied with how vigorously or quickly the state is enforcing its own laws. Quite the contrary, the founders reserved that power and others to the states in the 10th Amendment. Keep following Executive Coup for further updates on this matter and others related to the apparent executive coup attempt that is unfolding in the U.S. federal government at the direction of President Donald J. Trump. Thank you.